Hello, and welcome to the latest edition of Legal Bites, the official podcast of Cummings and Cummings Law, where we focus on helping businesses and their owners re-domesticate out of volatile legal and tax environments like Illinois to more predictable pro-entrepreneurship, pro-growth jurisdictions. Today, we are reviewing a recent report by Zero Hedge entitled Massive Fumble. Chicago Bears leave blue state Illinois for Indiana after a century of football. Following that, I will explain how small and medium sized businesses and their owners are taking advantage of the same legal mechanism to put Illinois in their rear view mirrors, regardless of their political party affiliation. But first, a brief introduction. My name is Chad Cummings, and I am an attorney and certified public accountant serving clients in matters of business, tax, and commercial law. I am Chief Executive Officer of the multi-state, multi-attorney law firm Cummings and Cummings Law. And in addition to my day job, I also teach business and tax law at the university level. I hold 4 degrees, including 2 law degrees, together with a bachelor's degree in accounting and a master's degree in taxation, in addition to 11 professional licenses and certifications spanning accounting, tax, audit, and of course, the law. My firm website is www.cummings.law. On to business. The Chicago Bears played football in Chicago for 106 years. Now they are leaving for Indiana, 25 miles from Soldier Field. The franchise's board of directors voted to pursue a new stadium development across state lines after years of failed negotiations with Illinois over public funding for a new venue. Meanwhile, Indiana passed a funding bill in less than 2 months. They were there for over a century. The Bears are one of the founding members of what became the NFL. They have played in Chicago since 1921. The franchise did not cite state tax policy or the broader business environment in its announcement because it did not need to. Illinois could not close a stadium deal in years, whereas Indiana closed one in 2 months. That is not a negotiation failure. Rather, that is a statement about which state wants business and which does not. Illinois ranks, as I have previously explained on earlier editions of Legal Bites, in unenviable position number 38 on the Tax Foundation's most recent state tax competitiveness index. That is not good. Higher numbers represent lower rankings, whereas Indiana ranks number 10, significantly better. Illinois imposes a combined corporate income tax rate of 9.5%, the third highest in the United States, whereas Indiana's corporate rate is a much more reasonable 4.9%. Illinois has a flat individual income tax rate of about 5%, but the legislature is pursuing a constitutional amendment to the state's constitution that would impose a 3 percentage point surtax on income above $1 million, bringing the top rate to almost 8%. For pass-through entities, and by the way, almost 95% of small and medium-sized businesses in the United States are pass-through entities, the rate would reach almost 10% with the personal property replacement tax. Meanwhile, Indiana's individual rate is 3%, scheduled to drop to 2.9%. Illinois has the highest property taxes in the nation. Its pension system is the worst in the nation, and it is funded at only 52%, meaning that for every dollar Illinois owes in future public pension obligations, they have only 52 cents in their pocket, and you know where the money's going to come from. IRS migration data show Illinois experienced the fourth highest rate of population loss to other states, and the top destinations for departing Illinois residents were Florida, Indiana, Texas, and Wisconsin. Indiana did not win the Bears by accident. It won them by being the state that could say yes. That pattern is the same pattern playing out in every sector of the economy. Samsung left New Jersey for Texas. Dell Technologies redomesticated from Delaware to Texas. ExxonMobil redomesticated to Texas. You're sensing a theme here. Tesla redomesticated to Texas. The mechanism differs. Some companies relocate operations, some companies change their legal domicile, and some do both. The common element is the direction out of high tax, high friction states and into states that compete for the business. The Bears are not a tech startup. They are not a company that can operate remotely. Rather, they are a 106-year-old institution with deep generational ties to a city and a fan base. If an institution with that breadth and depth of connection to Illinois concluded that the cost of staying in the land of Lincoln exceeded the cost of leaving in favor of Indiana, the calculation for a business owner with no comparable ties is much easier. For business owners operating pass-through entities in Illinois, the tax exposure is frankly abysmal. They hate small and medium-sized business owners. Do not take my word for it. Go read the tax code yourself. And the proposed constitutional amendment would lock a graduated income tax into the state constitution with no legislative mechanism to reverse it short of another constitutional amendment. The public pension system requires future revenue that the state simply does not have. The property tax burden is the highest in the country. 4 neighboring states have all enacted income tax rate reductions and remain on downward trajectories, which is a good thing. Meanwhile, Illinois is moving in the opposite direction and driving business owners out en masse. The Chicago Bears stayed in Illinois for 106 years, but they are not staying anymore. Indiana passed a deal in 60 days that Illinois could not close in a period of years. Meanwhile, other states offer even more favorable business and tax environments. For example, Florida and Texas, to name 2, impose no state-level personal income tax, and most small and medium-sized businesses in these 2 states pay no business entity-level income tax either. If the Bears could not justify remaining in Illinois, the question for every other Illinois business owner is, how much longer will you wait? With this context in mind, redomestication, let me say the word again because it is a mouthful. Redomestication is the lesser known legal process of transferring a company's state of domicile to a new state without dissolving it, without creating a new entity, and without triggering federal income tax consequences, but only when performed with the strict formalities required by the Federal Internal Revenue Code, applicable Treasury regulations, and the statutory frameworks of both the destination and departing states. When executed by a competent professional, keyword there being competent, the company retains its existing federal employer identification number, contracts, credit history, and bank accounts. That is to say, there is zero operational or financial disruption. I have successfully completed redomestications from all 50 states, including Illinois, and for limited liability companies, partnerships, subchapter S corporations, and subchapter C corporations. And not to brag, but we do have a 100% success rate to date. Foreign entity registration is not the same thing as redomestication, because foreign entity registration, also referred to as foreign qualification, does not change the company's domicile. In fact, it does the opposite by keeping the company in the former state, Illinois in our example, indefinitely, merely adding another layer of compliance and tax obligations in the destination state. Meanwhile, a traditional merger, which is also not the same thing as redomestication, creates a new distinct entity in that destination state, may require the issuance of a new federal employer identification number, and can trigger serious tax complexities. Finally, dissolution should not enter the conversation at all, because dissolution terminates the company. Dissolution is a going out of business option, not a relocation mechanism. And dissolution is often a taxable event. And when performed inadvisedly, can expose the owners of the company to unlimited personal, emphasis on that word personal, joint, and several liability for the company's liabilities, known and unknown, because the so called veil of protection no longer exists. If you have a so called professional suggesting dissolution as a relocation strategy, please seek better advice before you make a serious, uncorrectable mistake. Redomestication, when paired with a change of personal residency and that is an important and, a reduction or outright cessation of business operations in Illinois, can reduce or even eliminate state tax exposure there for the entity and its owners. Don't take my word for it, ask your CPA. Now is the time to consider acting before the Illinois legislature in Springfield considers changes to the statutes to hinder or even eliminate the option of redomestication. If you have questions regarding potentially redomesticating your existing LLC or corporation out of Illinois or out of another business unfriendly state, please use the link in the description for more information on this process and to schedule time for you and I to speak one-on-one about your specific scenario. Again, my name is Chad Cummings, and I hope that you found this information helpful. As always, the information in this presentation is necessarily general in nature and is not legal or tax advice, nor should it be construed as such, because that advice definitionally must be specific to a particular set of facts and circumstances. Should you have any questions regarding this information or the content of any of my many earlier presentations on these topics, please visit my firm website at www.cummings.law, not .com, but .law, to schedule time for a consultation. I look forward to that opportunity to speak and perhaps even work with you very soon.